also think that's important because one way in which Black people's civil rights are undermined is the way in which the criminal justice system targets our communities. And stop and frisk really allow for that to just go amok. As Justice Douglas said in his dissent, now you have a totalitarian path that we are on. And it eventually leads ways to blatant discrimination. What's up, everyone? It's me, Brooke. Welcome back to the Untold series, where each week I look at what I think are important civil rights cases. I discuss them, break them down, and tell you why I think they're important. Whether you've joined Facebook, YouTube, Instagram, or even the podcast, welcome. Okay, so I'm kind of excited, although I don't know if excited is the right word, but I'm excited for this case this week. It's Terry versus Ohio from 1968, and it deals with a very hot topic issue, which is stop and frisk. They're actually two different terms. We'll talk about that a little, but let's get into the facts of the case. Picture it. It's All Hallows Eve, also known as Halloween, 1963, 2:30 in the afternoon, and Martin McFadden, who was a 35-year detective, 39 years on the force, but he had been a detective for 35 years. He's in plain clothes, and he sees these two gentlemen going up and down the street looking into a store window. And one would go up, look in the window, come back, and the other one would go up, look into the window, come back. It was real odd, honestly, or at least it sounds odd. And they did this a few times. Then a third gentleman joins them, and he leaves. Then they do that up and down thing again, and then the third gentleman comes, and then by this time, Detective McFadden had had enough. He had seen enough. He goes over to them, asks their names. He says they mumble something, and then finally turns the first gentleman around, whose name is John Terry, and that's how we get the case name. Turns him around, and he's trying to pat him down. He puts the gentleman, throws him, or takes him into the store, and he pats John Terry down and finds a gun. Then he pats the second guy down. His name is Richard Chilton. Pat him down, find a gun. The third guy, his name is Carl Katz, pats him down. Well, actually, according to the Supreme Court case, it says there's no record whether or not he patted this guy down. Oh, and by the way, John Terry was Black. Richard Chilton was Black. Carl Katz, not so much. He was a white man. Anyway, once Detective McFadden finds the guns, the concealed weapons on Terry and Chilton, he arrests them for having a concealed weapon. Terry, according to his attorney, was a drug user, and so he had a little bit of a record. Chilton, on the other hand, did not have a record, and neither did Katz. He arrests all three of them. Eventually, Katz is released and not charged with anything, but Chilton and Terry, they are brought up on charges for carrying a concealed weapon. Now, Terry and Chilton, they were represented by an attorney named Louis Stokes. And at this time, just to back up a little bit, so this is 1963. What happened in 1961 was another important Supreme Court case called Mapp versus Ohio, which was complicated. It dealt with Don King, yes, that Don King, a bomb threat, a Black woman who was indicted for having porn, and the exclusionary rule. In that case, the court said the exclusionary rule applied to the states. Now, you're like, what is the exclusionary rule? What are you talking about? You're speaking, what is that? I'm glad you asked. The exclusionary rule essentially is this, that if the police obtain evidence through illegal searches, then that evidence will be excluded from being admitted into court, because there has to be a deterrent from illegal searches. So the court says, okay, you can spread that, because it applied before Mapp versus Ohio, it applied to federal cases. Now that applies to the state as well. That's in the background. That's just 2 years prior to this. And so Louis Stokes said, okay, you know what? I think this search was illegal. And because Mapp says that the exclusionary rule can apply at the state level, let me file a motion to suppress this evidence of the weapon. And if there's no weapon, then there's no concealed weapons charge. So he files a motion to suppress. And during that, he cross-examines Detective McFadden. And he asks some poignant questions. One, why did you decide to look at what drew your attention to these two gentlemen, Terry and Chilton? And he says, honestly, I just didn't like them. And I'm not making this up. So then the attorney Stokes said, okay, you've been a detective for 35 years. You've been on the force for 39 years. Have you actually ever observed anybody getting ready to stick up an establishment? And he was like, no. He files this motion to suppress. There's a hearing because you have a hearing for a motion to suppress. And the court ruled against him. So Stokes appeals it to the appellate level, I think the district court, and then to the Ohio State Supreme Court. He loses at each point, and then finally he appeals to the United States Supreme Court. So by the time he gets to the United States Supreme Court, it is 1967, and a lot has changed from when they decided the MAP decision in 1961. So you have a lot more protesting going on. I mean, it's the 60s, come on. And so a lot more social unrest, and people are concerned about that. And so by the time he gets to the United States Supreme Court, those things are in the back of people's minds of how do we protect the police against what is perceived as lawlessness. So those are the facts that lead us to the United States Supreme Court. The issue in this case is pretty straightforward. It's whether or not the stop and frisk that McFadden gave to Terry, Chilton, and Katz, whether or not that violated the Fourth Amendment. The holding. The court said no, it did not violate the Fourth Amendment. The reasoning. Okay, so first it's important to note that stop and frisk are two different things. I know we say them almost like synonymously, like stop and frisk. But the stop is when McFadden first said, hey, what's your name? What are y'all doing? And so there needs to be an approval for that. And then the frisk, which is the patting down that he did to find the gun, that's something separate. So there has to be some kind of constitutional permittance of that as well. Now Terry, through his attorney Louis Stokes, argued that only if he had probable cause to arrest could he have searched them and done the frisk. The court said no to that as well. What the court said is there has to be essentially this balancing act. So the court says, look, if an officer has reasonable suspicion based upon specific and articulable facts that a crime has been committed or is about to be committed, then he or she can go over and do what's called an investigative stop, where you're just asking some very simple questions like what's your name, and then because of the potential for danger to the officer, he or she can do what's called a pat down, and you're searching for weapons. Now, again, think this is in the 1960s, so the fear of lawlessness because of the social uprising going on in the background is there. So there's like, well, the police have to be able to protect themselves by doing very basic pat downs for weapons, for hard objects, and that this whole encounter should be very short. And based upon all of that, then that does not violate, or rather, the Fourth Amendment does not prevent them from doing these types of stops. Now, I normally don't do dissenting voices, but I feel like this one was important, and there was only one dissenting voice. It was an 8-1 decision. It was Justice Douglas, who found that the court got it wrong, that you can't give more power to a cop than a magistrate, because in order to arrest someone, a magistrate would have to find that there's probable cause. And here you're giving the police officer something less than that, just reasonable suspicion, and they're allowed to make the decision right there on the street without having the safeguards that the Fourth Amendment has in place. And he also says something very important that I think, just again, is one of those things you just got to read into the record. He says, to give the police greater power than a magistrate is to take a long step down the totalitarian path. And then he reiterates that, and he says, there have been powerful hydraulic pressures throughout our history that bear heavily on the court to water down constitutional guarantees and give the police the upper hand. The hydraulic pressure has probably never been greater than it is today. These words still ring true, do they not? Yet, if the individual is no longer to be sovereign, if the police can pick him up whenever they do not like the cut of his jib, if they can seize and search him in their discretion, we enter a new regime. Now, it's important to note that at this time, you have Justice Thurgood Marshall on the court, the first Black justice on the Supreme Court. I would argue the only one, but you have the first Black justice on the Supreme Court, the civil rights legend, and he actually sides with the majority here. He agrees that this stop and frisk is constitutional, which I find very remarkable. So that's what happened. Terry lost at all levels. He was on drugs, so he got into a little more trouble afterwards, and I don't have any major update on him. Chilton, on the other hand, who prior to this case didn't have a record, but I don't know what happened to him. He got involved in the wrong crowd, I guess, and he eventually died in a shootout during a burglary going bad, or just a burglary. And so in 1967, before the Supreme Court even made its decision. So that was a very tragic end to it. And then Katz, I don't know what happened to him. I just know he didn't get charged or arrested for anything. So why is this case important? Why have I included it in my long run of civil rights cases? Because this isn't a case necessarily dealing with specific civil rights legislation or laws or amendments. But I think it's still important. One, I wanted to give some educational information about what a stop and frisk should be. It should be if there's reasonable suspicion based upon specific and articulable facts that you are committing a crime, that a person has committed a crime or is about to commit a crime. Then the officer can do an investigative stop and they can pat you down, but that's only they're looking for weapons. So they're patting you down for hard objects. They can't go into your pockets. They're looking for if there's something soft there, thinking it may be drugs or whatever. But of course, that's what should happen. What actually happens, we all know, is something completely different. But that's some education that I wanted to make sure you all are aware of. And so you know your rights. Whenever someone's stopping you, ask, what's your reason? Do you have reasonable suspicion of what I'm doing? And I also think that's important because one way in which Black people's civil rights are undermined is the way in which the criminal justice system targets our communities. And stop and frisk really allow for that to just go amok, as Justice Douglas said in his dissent. Now you have a totalitarian path that we are on, and it eventually leads ways to blatant discrimination. That's what happened in the stop and frisk case in New York City. A lot of people said it found stop and frisk unconstitutional. That's not correct. Stop and frisk, according to Terry versus Ohio, is still constitutional. But what the court said there is that the way in which the New York City policy of stop and frisk operated, it violated the equal protection rights of Black and brown citizens. You had 59% of people being who were stop and frisk being Black citizens, but Black people only made up 24% of the New York City population. So the way in which it was handed out had a disparate impact on Black people. This case is also important because it highlights the way in which a case need not be explicitly civil rights in the way that we saw before, like with grandfather clauses and voting districts and all of that stuff, to still impact the civil rights of Black and brown people. Terry really sanctioned the erosion of the specifically the Fourth Amendment constitutional rights of Black and brown people, and that's important to note. There was a theoretical position that the court took, and it seemed to make sense on its face. Like I said, you had Justice Thurgood Marshall agreeing with it, but its implication and the way that it's implemented, you see that it actually is quite discriminatory, especially when you have a police force that is suspicious of Black people. Remember, McFadden said he just didn't like them, and that's what caused him to then pay attention to them, and that's what led to all of this. And I think that kind of attitude, if we're not also addressing that in the way in which we interpret the Constitution, the way in which we write our laws, then we're just going to have these unjust outcomes until finally another judge, like the judge in New York City, say, okay, no, this is the way in which you are implementing this policy is unconstitutional. If you like this video, please be sure to hit the like button. Please leave me a comment. I would greatly appreciate that. Please share it on whatever platform you're on. Also, be sure to follow me on Facebook, on Twitter, on Instagram. I'm on Patreon. So if you could, I would greatly appreciate any support you could give there. Also, please subscribe to my blog, palukisworld.com. If you subscribe there, you'll never miss one of these videos. And also be sure to subscribe to the podcast. I am on iTunes and Spotify. So now you have multiple options. I would greatly appreciate it if you left a review. Obviously, 5-star reviews are preferred. But leave a review that helps people discover the podcast as well. So I would greatly appreciate that. Thank you so much for watching. And if you haven't already, go out and register to vote and then vote. Okay? All right. Until next time, take care. God bless.